back from lunch, and we can go ahead and get started again. We're ready for our first witness, which I believe is John Reed.
Yes, Your Honor. We would call Mr. Reed.
Good afternoon, Mr. Reed. Please raise your hand. Solemnly swear or affirm the testimony you're about to give in this matter is truth, the whole truth, nothing but the truth.
I do.
Thank you. You may inquire.
Please state your name.
My name is John J. Reed.
By whom are you employed and in what capacity?
I am the Chairman and Chief Executive Officer of Concentric Energy Advisors.
Are you appearing today on behalf of the Empire District Electric Company, which does business as Liberty?
Yes.
Have you caused to be prepared for the purposes of this proceeding certain rebuttal testimony in question and answer form?
Yes, I have.
Is it your understanding that your rebuttal testimony has been marked as Exhibit 1 for identification?
Yes.
Do you have any changes that you would like to make to that testimony at this time?
I do not.
If I were to ask you the questions which are contained in Exhibit 1 today, would your answers be the same?
Yes, they would.
Are those answers true and correct to the best of your information, knowledge, and belief?
Yes, they are.
Your Honor, at this time I would offer Exhibit 1 into evidence and tender the witness for cross-examination.
Okay, Exhibit 1 has been offered. Any objections to its receipt?
Your Honor, may I voir dire the witness very briefly?
Yes, you may.
Okay.
Let me first of all identify yourself for the record.
Oh, yes. Kurt Stokes on behalf of staff.
Thank you.
Mr. Reed, are you a licensed attorney in the state of Missouri?
No, I'm not.
Are you licensed as an attorney in any state?
No, I'm not.
Okay. Based on that, Your Honor, staff has a limited objection to page 7, line 3, through page 8, line 2, page 21, line 1, through page 22, line 4, footnotes 20 and 21, page 9, line 14, through page 12, line 20, footnotes 1, 2, 3, and 4, and page 11, line 1, page 12, line 9. The basis of the objection would be to the extent that that testimony purports to establish the state of the law. The witness's testimony on that is irrelevant, lacks foundation, and it's an improper lay opinion as to the state of the law. We do not have an objection only to the extent that it forms the basis of Mr. Reed's opinions and does not purport to state what the law is in Missouri.
Response?
Your Honor, it's going to be difficult to respond in a lot of specificity given that that objection was just now raised and without taking time, I guess, to go back and read those provisions. However, argument would certainly be that Section 490.065 in Missouri establishes the admissibility of expert testimony. Subsection 1 talks about the situation where there's no right to a jury trial, which there is none in this case, and says if scientific, technical, or other specialized knowledge will assist the trier of fact to understand the evidence or to determine a fact and issue, a witness qualified as an expert by knowledge, skill, expertise, training, or education may testify thereto in the form of an opinion or otherwise. Testimony, and I'm going to kind of condense this a little bit, is not objectionable because it embraces an ultimate issue to be decided by the trier of fact, regardless of Mr. Reed's position or status as an attorney or not. We would argue that his 45 years of experience in the industry, his testimony and variety of cases over the years to include specifically the prudence standard as an expert establishes his qualifications to testify in this matter and to testify to the matters that are included in his rebuttal testimony.
And just for the record, the last speaker was Dean Cooper, attorney for
I apologize.
for Liberty. And it was Mr. Cooper who was also asking the questions on direct. I'm going to go ahead and overrule the objection. The testimony will be received for what it's worth, and the commission can later decide how best to treat it. Do you tender the witness?
We do, Your Honor.
Oh, I'm sorry. Did anyone else have any objection? All right. Then exhibit number 1 will be received. And for cross-examination, we will begin with Renew Missouri.
Renew Missouri has no questions for this witness. Thank you.
Thank you. MECG?
No questions, Your Honor.
Staff?
Yes, Your Honor. Kurt Stokes on behalf of staff. Mr. Reed, you say that you've appeared before the Missouri Public Service Commission 32 times?
I think that's correct.
If you turn to Exhibit 1, page 2 of your rebuttal, can you confirm there that it's, you said 32 times?
Give me just a moment. Yes,
31 of those times you appeared on behalf of a regulated utility?
I'll accept your count. I think that's about right.
How much are you being paid to testify in this case?
My company will charge my normal hourly rate. I think it is, for this assignment, about $900 an hour.
You state in your rebuttal at page 7 that under traditional cost-based rate making, a utility is permitted to include prudently incurred costs in the revenue requirement used to set its rates. Is that true?
Correct.
We've already established you're not a licensed attorney in the state of Missouri, correct?
We have.
Are you familiar with the Missouri Supreme Court?
I am.
And you understand the Missouri Supreme Court interprets the laws and sets binding precedent?
For the state of Missouri, yes.
Your Honor, permission to approach the bench and the witness with pre-marked Exhibit 109?
You may.
And this is still Kurt Stokes. Mr. Reed, are you familiar with, you know what, I apologize. I meant to approach with a different exhibit. Your Honor, permission to approach the witness again?
You may.
Now, this document says Spire Missouri, Inc. versus Public Service Commission on the top at page 225, correct?
Correct.
Can you turn to page 233 of that document, please?
Your Honor, this is Dean Cooper for Liberty, and I guess this is directed to Mr. Stokes. Is this an exhibit, and if so, do you have a copy for us?
It's not an exhibit yet. I think I can lay a foundation for it. It's the Spire Missouri, Inc. decision in 618 Southwest 3rd, 225. It's a 2021 Missouri Supreme Court decision.
Do you have a copy you can share with the other parties?
I think I thought I did, Your Honor. Here.
Let me see where you are.
618 Southwest 3rd, 225.
You can proceed when you're ready.
Okay. So you see in the top right paragraph, do you see the phrase, Implicit in Spire's argument is an assertion that it is entitled to recover all prudent expenditures and its rates. This is not so. In setting rates, the PSC has broad discretion to include or exclude expenditures to arrive at rates it deems to be, quote, just and reasonable, unquote, subject, of course, to judicial review.
I see that phrase, yes.
Your Honor, I'd like to ask the Commission to take official notice of the decision in Spire, Missouri versus Public Service Commission, citation 618 Southwest 3rd, 225, Mo Bank, 2021.
Is it necessary to take official notice of a decision, or is this something that can be brought up in briefs?
No, I think it's important. Mr. Reed set forth in his testimony, which has been admitted in the record. I think it's important to make sure that that testimony is not completely unrebutted or uncontested, that utilities are automatically entitled to recover prudent costs.
Mr. Cooper?
Yeah, Your Honor, this is Dean Cooper. I don't think that taking judicial notice of the existence of the case establishes a fact other than that, or a premise of law necessarily. It establishes that these words have been said by the court, and I think it's open to the parties then to argue to the extent they desire as to what meaning that has for this particular case. So I guess I may have heard Mr. Stokes incorrectly, but a roundabout saying, I don't know that it's necessary to take judicial notice of a Supreme Court case.
Anyone else wish to be heard? I'm not inclined to take official notice of a court decision. Certainly the parties are entitled to cite this in their arguments. I don't see that taking official notice of it adds anything to the record that the commission makes its decision on. So I'll overrule your request for official notice.
Mr. Reed, have you ever worked on an air permit?
No, I don't believe so. I've been involved in many applications that involve securing air permits. I don't think I've been involved in submitting an air permit to an environmental regulator.
Now, you also state at page 23 of your rebuttal that the commission approved the inclusion of the unamortized balance of storm costs from the Joplin tornado in the company's rate base.
Correct.
Now I'm going to hand, well, I've already handed you Exhibit 109. And you recognize that as the commission, a portion of the commission's amended report and order in file number ER-2019-0374?
It appears to be.
Can you turn to page 154 of that decision?
I have that.
And paragraph 423, the last sentence of that paragraph says, Empire was allowed to defer depreciation expense and carrying costs associated with the tornado-related capital expenditures, correct?
Yes, it begins by, of course, saying to defer, the commission authorized Empire to defer incremental O&M expenses incurred for the repair, restoration, and rebuild activities associated with the May 22nd, 2011 tornado. It then continues to say Empire was also allowed to defer depreciation expense and carrying costs.
And paragraph 425 states that the AAO permits Empire to accrue a carrying charge equal to its AFUDC rate on its tornado capital additions during the deferral period to offset the lack of a current return on its tornado-related capital additions. Is that correct?
During the deferral period, that is up until the amortization was set including the unamortized amount and rate base.
Correct. And you can agree that an AFUDC rate is lower than the weighted average cost of capital, correct?
Yes, as an interim measure, it adopted a lower rate.
No further questions, Your Honor.
Did you wish to offer 109?
Would the commission, admit Exhibit 109 and/or take official notice of the commission's amended report and order and file number ER-2019-0374?
We'll take this as an offer of the exhibit at this point. Any objections to the receiving the Exhibit 109? Hearing no objections, it will be received. And Mr. Stokes, I believe this, since this was pre-numbered, this has already been submitted into the website?
That's correct, yes.
Okay, thank you. For cross-examination, then going over to public counsel.
Thank you. Nathan Williams for the Office of Public Counsel. Mr. Reed, what participation have you had in Liberty's resource planning?
None directly. I've been involved in their rate
Thank you.
cases, but not resource planning directly.
Judge, I asked that the latter part of the response be stricken. My question was limited to resource planning, nothing to do with rate cases per se.
I'll grant that.
No further questions, thank you.
All right. Then we'll come up for questions from the bench. Any commissioners on the line wish to ask any questions?
Not at this time, Judge. Thank you.
Thank you, Chairman. No questions from the bench, so no need for recross. Any redirect?
Yes, Your Honor. Dean Cooper for Liberty. Let's start with that last statement. You were asked about your participation in Liberty resource planning by OPC counsel, correct?
Correct.
Have you been involved in prior Empire District Electric Company / Liberty cases?
Yes.
Judge, I'm going to object to that. The question was limited to resource planning. He's going way beyond that.
Your response, Mr. Cooper?
Judge, I think it's appropriate for redirect to allow the witness to further explain his involvement with the company.
I'll overrule the objection.
Mr. Reed, do you remember the question?
I do.
Okay. Would you go ahead and answer?
Yes, I have been involved in rate cases for Empire District Electric, including its most recent electric case and most recent gas case.
Mr. Stokes asked you some questions in regard to a Spire, Missouri case. Do you remember that?
I do.
And in particular, that concerned PSC's broad discretion in arriving at rates it deems to be just and reasonable, correct?
Correct.
In this case, does the securitization statute have any definition of what is just and reasonable in terms of what can be recovered?
This is Kurt Stokes for staff. Objects to the extent that it asks for a legal opinion.
This is Nathan Williams for Public Counsel. I'll join in that objection.
I'll overrule the objections. You can answer.
I don't think the legislation has any standard or any explanation of what constitutes just and reasonable. The second part of your question was related to the types of expenses, as I heard it, that can be recoverable. It certainly does define the types of expenses, both in terms of extraordinary expenses and transition expenses that can be recoverable.
Now, when a commission determines what is just and reasonable, and to use the language, I guess, of the court case, is there also implicit in that decision the question of whether the company is going to recover a reasonable return on its investment?
Kurt Stokes for staff again with an objection. We are really getting into legal opinion now. a lack of foundation. We've already established that Mr. Reed is not a licensed attorney, and I think he's just been asked to read whether or not the Missouri Supreme Court implied a certain holding.
No. This is Mr. Cooper for Liberty. The question really has to do with what it's common for non-attorneys to testify to, which is appropriate rates of return, the implications of Bluefield, and those sort of things that, again, are commonly testified to by non-attorney witnesses before this commission.
I'll overrule the objection.
Do you need the question restated, or do you?
Could I have it again, please?
Sure. So in the case that was put before you, there was a statement about the commission's sort of flexibility, I guess, discretion in arriving at what it might find to be a just and reasonable rate. Are there, and I think this is in your testimony, in fact, are there other principles that are commonly addressed in rate cases that focus on the utility's opportunity to recover a reasonable return on its investment that figures into that decision process for the commission?
Yes, just and reasonable rates are typically thought of as those that balance the interest of consumers and investors, and that provide the utility with a reasonable opportunity to earn a fair return on its investments after deducting its operating costs. So it goes both to balance and to providing a reasonable opportunity to earn the fair return.
Mr. Reed, the Spire case that was put in front of you, were you familiar with that case?
Yes.
Do you remember the subject matter that was being discussed by the court in regard to the provision or the portion that Mr. Stokes read?
Yes, that portion of the decision is referring to the inclusion or exclusion of rate case expenses in the utility's cost of service or revenue requirement.
And not capital investment, I suppose.
And not capital investment or any operating expense. It's an administrative expense.
That's all the questions I have, Your Honor.
All right, then, thank you. And you can step down.
Thank you.
Next witness is Aaron Dahl.
Yes, we call Mr. Dole to the stand, please.
Your Honor, I apologize before you swear in Mr. Dahl. Mr. Reed is not scheduled to be on the stand any further this week. We're asked whether he can be excused to travel back home, but understanding that he would be available if it became necessary to appear by WebEx later in the week.
You can be excused.
Judge, this is Nathan Williams. From my perspective here, I see there's a display on a computer where the witness is sitting. I don't know. It looks like a spreadsheet, but I don't know what that's about.
It's displayed. It's displayed up there.
It's not.
The witness, you want to see the camera? We don't need it. Yeah. We're not using that at this moment. I'll have it.
So the witness turned off the screen. Is that what's happened?
I minimized it. I don't know what it was.
Okay.
Not mine.
Spreadsheet of some sort.
Somebody.
Does that satisfy your concerns, Mr. Williams?
Yes.
Okay, thank you. Okay, if you'd please raise your right hand. Do you solemnly swear or affirm the testimony about to give in this matter is the truth, the whole truth, and nothing but truth?
I do.
Thank you. You may inquire.
Thank you, Judge. Mr. Dole, if you will please state your full name.
My name is Aaron J. Dole.
By whom are you employed and in what capacity?
I'm employed by Liberty Utility Service Corp. I'm the Senior Director of Energy Strategy for Central Region.
And does that include the Empire District Electric Company?
It does.
Did you prepare and have pre-filed testimony that has been marked Exhibits 2, P, and C, as in public and confidential? 3, public and confidential, and 4, public and confidential?
Yes.
Do you have any changes for that pre-filed testimony?
No.
If I asked you those same questions today, would your answers be substantially the same?
Yes, they would.
And are all of those answers true and correct to the best of your information, knowledge, and belief?
Yes, they are.
I would move for the admission of Exhibits 2, 3, and 4. All of those are both public and confidential versions, and then tender Mr. Dole for cross-examination.
All right, Exhibits 2, 3, and 4 have been offered. Any objections to their receipt? Hearing none, they will be received. And for cross-examination, we begin again with Renew Missouri.
Renew Missouri has no questions. Thank you.
Thank you. For MECG,
No, thank you, Judge.
for staff.
Kurt Stokes for staff. Mr. Dole, in your direct testimony exhibit 2, page 13, you say that Liberty retained a third-party Utilicast to conduct an independent review of Liberty's fuel procurement, generation operations, transmission and distribution operations, communications, and market operations during Winter Storm Uri. Is that correct?
That is correct.
And Liberty entered into a contract with Utilicast, correct?
That is correct.
And one of the consulting services agreement dated September 24 of 21, is that correct?
I'd have to look at the document.
Permission to approach the bench.
You may. Okay.
Thank you.
This is a consulting services agreement dated September 24th of 21. Is that correct?
That is correct.
Does that refresh your recollection?
Yes, I just wasn't sure on the date.
Okay. Now, that agreement requires, at page 10, that the consultant will share draft findings and recommendations for each area with company team leads prior to inclusion in final draft report, correct?
Which number was that?
Page 10, it's the very top. It's the very top.
That is correct.
And under deliverables, paragraph 2, that provides that that the Utilicast will provide written testimony from the Utilicast project lead with a summary of the findings of the incident analysis report for inclusion in the Missouri Public Service Commission rate or securitization proceedings. Is that correct?
That is correct.
And the rate for Utilicast is $255 per hour, regardless of the consultants.
Where do you see that at?
Page 11, third paragraph down.
Yes, I believe it was a cap on the hours with an hourly rate.
And speaking of cap on the hours, The company and Utilicast entered into a addendum number 1 on December 15th of 2021, correct?
Do you have that document?
Permission to approach the bench and the witness again, Your Honor?
Okay.
So I'll ask again, you see this document titled Consulting Services Agreement Addendum Number 1, is that correct?
Yes, that's correct.
And does that refresh your recollection that it was entered December 15th of 21?
That is correct.
And you said the original had a cap on hours, correct?
That is correct.
And paragraph 3 of this addendum removes the total cap on consulting hours? Under the now therefore clause on the first page?
You said paragraph 3.
Or provision 3, yeah.
Yes, that's what the document says.
And that's referring to this case, correct?
Referring to the original document.
Meaning the hours worked for this case, the securitization case?
I assume it's all consulting hours, whether it's report writing, the new material, or the testifying.
Now, you also say in your rebuttal at page 4 that March was the earliest possible retirement date for Asbury per SPP guidelines. Is that correct?
Which line?
Lines 20 through 22.
In my direct testimony?
Oh, I'm sorry, your rebuttal.
Can you repeat the question?
Yeah, you say that March is the earliest possible retirement date for Asbury per the SPP guidelines?
That were in place at the time, yes.
Okay. And the SPP guidelines are based on when the utility notifies SPP of a potential closer, correct?
That is correct.
And was Liberty reminded of that protocol of notifying SPP before retiring Asbury?
That is not correct.
Okay. You agree that Asbury was last generated power for customers in December of 2019?
That is correct.
And beginning in January of 2020, there was no usable coal at Asbury?
There was no usable coal on the ground. We were still pursuing delivery of coal.
Okay. But there was no actual contract in place to provide coal to Asbury?
There was no long-term transportation contract in place.
Okay. No further questions, Your Honor.
All right. Public counsel.
Thank you, Nathan Williams. Good afternoon, Mr. Dole.
Good afternoon.
Why did Liberty not continue to have arrangements to deliver coal to Asbury after December 12th of 2019?
So when the company was evaluating the retirement of Asbury, would have been in the fall of 19, we were doing some simulated runs on how much coal it would consume based on our contracts. And the company made the decision based on sensitivity analysis using different capacity factors of when the unit would run out of coal. The company made the decision not to pursue additional deliveries after that point, as it looked like we could run out of coal somewhere between November of 19, I think all the way till June of 2020. And so the company did not want to pursue additional deliveries of coal and risk stranding that asset on the ground.
And it ran out of coal in December 12th of 2019, correct?
Usable coal.
on-site coal, correct?
Usable on-site coal.
Could not Liberty have diverted shipments if it was going to have excess coal, resold it?
I don't know that we could have diverted shipments on our rail line to somebody else. We did pursue additional spot deliveries of coal, but we never found an economic mix.
Why didn't you extend your long-term contract for any period?
Because the unit was at that point slated to be retired March 1st, 2020.
How much did it cost for a train load of coal to be delivered? How much was the coal cost?
I don't know that I can tell you that offhand.
Not even ballpark?
Not with any certainty.
Is the coal that was burned at Asbury any different than coal that was burned at Iatan or Plum Point?
There are some differences in the coal that's burned at Asbury. In particular, I'd recommend you ask that question of Dr. Mishimba or witness Sean Rooney. They're a lot more familiar with the actual specific operations of Asbury.
Is your answer you don't know?
I do not know.
In your rebuttal testimony, you testify to your opinion, I believe, at least. Ms. Mantle is attempting to use an extreme weather event after the fact to allege imprudence with regard to resource planning.
Can you tell me where, please?
Page 8.
That is correct.
Do you know anything about what Ms. Mantle said in prior cases about Liberty's resource planning?
In prior, what kind of cases?
Rate cases, savings plan, the customer savings plan case, the CCN cases for the wind?
I would be somewhat familiar, but it's been a while since I've read her testimony in those cases.
Well, didn't she challenge Liberty's resource planning in those cases?
It's possible, probable.
No further questions, thank you.
All right, then we'll come up for questions from the bench. Do any of the commissioners have questions? All right, I do have some questions.
Sure.
In your answer to, I believe it was to public counsel's questions, you made a point of referring to usable coal, as opposed to, I assume, unusable coal. What do you mean by that?
There's a certain amount of coal, especially sitting on a coal pile as long as Asbury had, that gets mixed with the earth. And we made a decision as a company when we started scraping toward the bottom, and we were getting coal that was not deemed usable or started to risk the unit, the safety of the unit, that we stopped. It doesn't mean that there's 0% of coal on the ground. It just means there's an amount that's considered kind of base mat.
Okay, that was going to be my next follow-up. You're talking about base mat because that's been an issue in this case also.
Correct.
Okay. Now, I have some other questions too. In Lena Mantle's rebuttal testimony for public counsel, she stated that she was not aware of Liberty performing any analysis outside of costs in your decision-making process to retire Asbury. Now, outside of the comparative cost scenarios presented in Liberty's 2019 IRP, can you explain what other factors and parameters were reviewed in your decision-making process to retire Asbury early? I can go over that again if you need me to.
If you give me the page, you said it was Lena Mantle's rebuttal testimony?
I do not have a page number for that.
Okay. Could you repeat the question then?
Sure. In Ms. Mantle's rebuttal testimony, she stated that she was not aware of Liberty performing any analysis outside of costs in your decision-making process to retire Asbury. Outside of the comparative cost scenarios presented in Liberty's 2019 IRP, can you explain what other factors and parameters were reviewed in your decision-making process to retire Asbury early?
Sure. Cost is a considerable factor in the IRP. In fact, I think the language of the IRP statute says it needs to be the most considerable factor, the PVRR. But other factors are considered. So For example, we have a resource adequacy requirement with the Southwest Power Pool, and that is to ensure that there is enough resources to adequately serve load at all times. And so we make sure that any plan that we push forward through our analysis is meeting the criteria of the SPP resource adequacy requirement.
And did Liberty meet that requirement?
We did.
You want to explain that?
That we met it?
Yeah, can you go into any more detail about how,
Sure.
what was involved with that?
Sure. So the Southwest Power Pool, as the balancing authority and planning authority, determines what the resource adequacy requirement is. It is kind of a confluence of state and RTO ISO guidelines, but they do have a directive from NERC to ensure that there's adequate resources to serve load because of their status as a consolidated balancing authority. So they do a very robust study biennially called a loss of load expectation study, LOLE study, and that does a series of analyses to determine probability of unit failures, extreme weather, a whole host of other circumstances, and then determines what is the criteria as far as what they call a planning reserve margin, a amount above what the utility forecasts it would need to serve its peak load to be able to accommodate what they call a planning reserve margin. And so that is done biannually, published. Anybody that is a member of SPP that serves load in SPP has to follow that. You can't siphon off other utilities. You have to have dedicated capacity to your load through your NITS or your point-to-point service.
Again, an issue raised by Ms. Mandel was that Liberty's replacement of Asbury with wind was not appropriate since Asbury is dispatchable while wind is not. How do you respond to her?
I think we're kind of confusing a couple issues. Yes, Asbury is a dispatchable resource. If you look at it just based on whether it's dispatchable or not, it is a dispatchable resource. It was also a resource that was struggling with economics. It had been struggling for some time, and the company made decisions to try to make it more attractive in the market. I think witness Sean Rooney has testimony on record to that fact. And so we look at the resources in a variety of ways. The wind resources through the planning models that were run by CRA in the 2018 Generation Fleet Savings Analysis and the 2019 IRP showed that retiring Asbury and adding wind was the most economical for the customers. And I believe even in the Generation Fleet Savings Analysis filed in 18, they did include options of keeping Asbury and adding wind, but that did not get selected.
Okay. Now, are wind units considered to be dispatchable?
It depends on your term. By SPP standards, they are considered dispatchable. They have to be. They're called dispatchable variable energy resources, or DVERs. There is such thing as NDVERs, but to the point of whether you can dispatch them up, you cannot, but you can dispatch them down.
Can you explain that to me?
Sure. So you can't get more wind than whatever the wind profile is at the time, but if there is a reliability issue and you need to push the wind down, you do have the ability to push the wind down.
Okay, so you can take less power from those wind turbines than their maximum.
That is correct, and that is a new rule by the Southwest Power Pool to ensure that you have every wind farm, even older grandfather wind farms, have to all be considered dispatchable variable energy resources.
Dispatchable downward.
Correct.
Okay. Again, talking about the wind units, what capacity were these units first listed as in the resource adequacy?
It depends on which IRP or which analysis you're talking about. So the way SPP does accreditation for wind resources, which is to say if you put in 150 megawatt nameplate resource, you don't get 150 megawatts of accredited capacity.
How much would you get?
It depends. So you can, if you don't have a proxy wind farm or you don't have 3 years of data or Met Tower data to be able to do the accreditation calculation that was in place at the time, you can use a default of 5%. You can use a proxy wind farm within, I believe it's 50 miles. You can also petition the Supply Adequacy Working Group for another proxy wind farm in similar range, or you can use Met Tower data. And then you do a credited capacity calculation that is a minimum of 3 years of your profile, and you take a 60% confidence level. So you essentially grab your top 3% of peak times for each season, and then you grab what the wind was blowing at those times, you sort it high to low, and you grab the 60th percentile, and that's what your credited capacity is. So it does get very technical, but it generally is somewhere in the 15 to 25, 30% range.
And do you know what these were rated at when they first came online?
I know what they're rated now. I don't know when they first came online. It depended on the filing. We could have used 5%. For planning purposes, we probably used a calculation of what the expectation would be, somewhere around 15%.
Okay. And what are they rated now?
They're rated, so SPP has changed their methodologies again. It is a lot more complex than the calculation I just told you. There is now what they call an effective load carrying capability, ELCC methodology. And it slates your wind farms into tier 1 and tier 2 and tier 3 capacity. So the wind farms we have rated right now, subject to check, I think are somewhere around 30% rated capacity. It would be filed in our SPP filing right now, so we can get that to the commission if needed.
Okay. And do you know when that was changed?
The ELCC is for this, I believe it's for this coming summer.
Okay, so for last summer would have been something different?
Yes, but they still did dry runs, so you could get an assessment of what your capacity would be. So we can show it both ways, and both ways it's larger than the 5% for certain, and it's generally larger than the 15%.
Okay. And do you know what the ratings were at the time of Winter Storm Uri?
Of the rated capacity,
Yes.
those were in various stages of construction, so I'm not sure what the capacity would have been during this. So Neosho Ridge would have been online, and I believe Kings Point and North Fork were still in construction during that period. But I believe they all three produced energy, but Neosho Ridge produced the most because it was, I believe, fully online at that point in time.
Okay. Well, that's all the questions I have then.
Okay.
Any recross based on questions from the bench, beginning with Renew Missouri? For MECG,
No, thank you, Your Honor.
for staff?
Just very briefly, Your Honor. Mr. Dole, earlier you referred to a NERC. Did you mean to, is that the North American Reliability Corporation?
Energy reliability.
Energy Reliability, yeah. Apologies. And you said that is a corporation, but is that designated by like a federal agency to?
I believe it's designated by FERC.
Yeah. And does NERC impose those resource adequacy requirements on SPP alone, or does Liberty also have some resource adequacy requirements?
So NERC requires any planning coordinator or BA to have a resource adequacy requirement. They are also, and I believe they've been on record acknowledging that states may have a different opinion, and resource adequacy is generally left to state jurisdiction if it can't be collaborative. And so the way SPP manages resource adequacy is they do their technical studies and they run it through their regional state committee, which is a commissioner from each state of market participants inside of SPP. If you're not a member of an ISO or an RTO, NERC requires you, I believe, to have a 15% planning reserve margin requirement is just a general rule.
Okay. You just said BA. Does that mean balancing authority?
Yes.
And is Liberty a balancing authority?
We are not.
Who is the balancing authority?
SPP is the balancing authority as of March 1st, 2014.
Thank you.
Anything else? Mr. Stokes, did you have any?
Oh, no further questions.
All right, thank you. For public counsel.
Thank you, Nathan Williams. In response to one of the questions from Mr. Woodruff, Judge Woodruff, you talked about the wind farms operating at least partially during Storm Uri. Were any of the revenues they generated, if they did so, directly of benefit to Liberty customers, retail customers?
We were not allowed to share revenue from the wind farms, but according to language in our FAC, until the wind farms were in rates. So none of that revenue could have been shared.
And does meeting the SPP requirements mean that during some event like Storm Uri, the energy will actually be produced by the resources that are underlie that meeting the SPP requirement?
I'm not sure. Could you restate the question?
Does having resources that meet the capacity requirements mean that the capacity will actually be available when it's needed during some kind of an event like Storm Uri?
The analysis that SPP does to determine
Yes or no, please.
their PRM. Okay. Does the I'm sorry, could you repeat the question one last time?
Does meeting the SPP capacity requirements mean that the capacity will actually be available at any given point in time?
It does not mean that it will be available at any given point in time without stop.
I think that's it for now. Thank you, Judge.
All right, any redirect?
No, thank you, Judge.
Then, Mr. Dahl, you can step down.
And Mr. Dole is not scheduled to take the stand later. May he be excused?
May be excused. And the next witness is Charlotte Emery then, I believe.
It is, Your Honor. This is Dean Cooper, yes. We would call Charlotte Emery to the stand.
Please raise your right hand. Solemnly swear or affirm testimony about to give in this matter is the truth, the whole truth, and nothing but the truth.
Yes.
Thank you. You may inquire.
Thank you, Your Honor. Dean Cooper again. Please state your name
Charlotte Emery.
and by whom are you employed and in what capacity?
I am employed by the Liberty Utility Service Corp. As the Senior Director of Rates and Regulatory Affairs.
Is that a new title since the filing of your direct and rebuttal testimony?
Yes.
Have you caused to be prepared for the purposes of this proceeding certain direct testimony in case number EO-2022-0193 and rebuttal testimony in both cases in question and answer form?
Yes.
Is it your understanding that your direct and rebuttal testimony has been marked as Exhibits 7 and 8 for identification?
Yes.
Do you have any changes that you would like to make to that testimony at this time?
No.
Is it your understanding that pursuant to the Commission's order, additional schedules to your rebuttal testimony that were identified as CTE-4 to CTE-15 were filed with the Commission on June 9th of 2022?
Yes.
And would you consider those additional schedules to be a part of your rebuttal testimony?
Yes.
As to some different pieces of testimony, I understand you are adopting some testimony. Are you adopting the direct testimony of Karen S. Hall and the direct testimony of Matthew DeCourcy, which was filed in case number EO-2022-0040?
Yes.
Is it your understanding that Mr. DeCourcy's direct testimony has been marked as Exhibit 5 for identification and Ms. Hall's direct testimony has been marked as Exhibit 6 for identification?
Yes.
Do you have any changes that you would like to make to that testimony at this time?
No.
If I were to ask you the substantive questions which are contained in Exhibits 5, 6, 7, and 8 today, would your answers be the same?
Yes.
Are those answers true and correct to the best of your information, knowledge, and belief?
Yes.
Your Honor, I would offer Exhibits 5, 6, 7, and 8 into evidence and tender the witness for cross-examination.
Judge, if I may,
Yes.
because the additional schedules to the rebuttal testimony, Exhibit 8, came in so late, we have not had an opportunity to review those, so I'd like to reserve an objection just so we have an opportunity to look at them and make sure they are work papers as they purport to be.
Do we want to pull them out as a separate exhibit? Would that aid in that process?
I don't think that's necessary.
Sorry. Okay. So those were filed last week, I believe, right?
They
Late
were,
last week.
yeah, Thursday, I think, Your Honor, but Been Friday.
They should have been, it's my understanding they were provided to the parties before that. Is that correct?
I don't know. Well, that's what I want to
You
confirm,
just
is
wanna
that those are work papers as they're.
You're looking to confirm that,
Right,
in fact, they are what they say they are.
yes. We haven't had time to review them to assure that's the fact
Okay.
what,
for the case.
yeah, Your Honor, this is Dean Cooper. I mean, it may make some sense to do what you were suggesting, which is break them up into a separate exhibit. I'm assuming that with that separation, then we could go ahead and have Ms. Emery's surrebuttal testimony minus CTE 4 to CTE 15 potentially admitted into evidence today. And in that scenario, we'd only be waiting on confirmation for the schedules.
I don't care how you do it, but I could see admitting the portions to which we're not asking to reserve the potential to object to it, which are the additional schedules.
Yeah.
However you want to handle it.
And Mr. Williams, would you be able to respond to the extra exhibits by the end of the hearing, or how?
I certainly hope so. I mean, it's not my intention to hold things up. We just want to confirm they
understand.
are what they purport to be.
Well, that's fair. All right, let's go ahead and pull those exhibits out to make them a separate exhibit. Your next number would be number 21.
In that case, Your Honor, I would offer, again, I guess, exhibits 5, 6, 7, and 8. I would also offer exhibit 21, understanding that the ruling on 21 may, or will come later.
Okay. All right, at this point then, 5, 6, 7, and 8.
Your Honor, I have just a quick request of voir dire the witness again.
Okay, go ahead.
Ms. Emery, are you a licensed Missouri attorney?
No.
Okay, Your Honor, based on that response, I would object to, as irrelevant, lack of foundation, and witness lacks the qualifications to provide a lay opinion, to page 19, line 14, through page 20, line 9. That is Exhibit 8 of Ms. Emery's surrebuttal. That portion purports to establish what the legislative intent and some legal analysis of the securitization statute. Pages 22, lines 12 through 17, purports to interpret what commission rules require. Pages 23, lines 5 through 7, and 23, lines 21 through 24, purports to interpret a statute and what it does and does not allow. And page 24, the full sentence at lines 14 and 15 purports to also say what a statute does and does not allow. That's improper lay opinion testimony about what the statute allows and does not allow. And it's also irrelevant.
Okay, and this is all in Exhibit 8?
This is Exhibit 8, surrebuttal, yes.
First of all, we'll go ahead and admit 5, 6, 7. Those were all without objection. As to Exhibit 8, I'm going to overrule the objection again. As Exhibit 21, again, been offered, I'll defer ruling on that until later in the hearing, after the parties have a chance to confirm that it is what it says it is. All right. And taking on my role as acting court reporter here, those exhibits were submitted already into the commission's website.
They were, but we may need to split out the schedules that we've been discussing into a separate exhibit and resubmit those, Your Honor.
If you would, please, to the, okay. For cross-examination again, then we begin with Renew Missouri,
No questions, Your Honor. Thank you.
MECG,
Yes, Judge, may I cross from my seat?
you may.
Tim Opitz, MECG. Good afternoon, Ms. Emery.
Good afternoon.
On direct, you noted that you didn't have any corrections to your testimony and your adopted testimony. When you filed your testimony, that was in March of 2022, is that correct?
Are you referring to?
To your
my-
direct testimony, I'm sorry,
In Asbury?
in the Asbury case?
Yeah.
And the Uri case, you're adopting the direct testimony of Ms. Hall, correct?
Correct.
And the date that she filed that testimony was in January of 2022?
Yes.
And at each of those testimonies includes the cost allocation method the company put forward for each asset, correct?
Yes.
And I believe it's table CTE 5 in your direct, the Emory direct. And it's just table 5 in Hall's direct. Do you have those with you?
Let me check just a moment, but
Okay.
I think I do. Yes, I have the table CTE 5 in my direct, and I also have the table 5 of Karen Hall's testimony.
And you understand from the rebuttal testimony of Sarah Lange and from the opening statement of staff today that one complaint about those tables is that it reflects customer classes that are not current customer classes?
Yes, I understood that there was a statement made that the EV was not included.
And these customer classes, are they the classes that are now in existence with the rates that have gone into effect on June 1st?
If we're referring to the EV tariffs, we did file some EV tariffs that took, but they don't actually become effective until, I believe, October 15th.
Were you a participant in the recent rate case?
Yes,
As a part of that rate case, some of the customer classes changed, is that correct?
yes,
And at the time at the time you filed your testimony in the Asbury case, those were the customer classes at the time, correct?
yes. There was consolidations in the other cases, yes.
And so your testimony in that would need to be updated to reflect the current classes if we were going to allocate it based on your method, correct?
The method in our direct, yes.
Method in your direct. And in your surrebuttal testimony, you state you've acknowledged the criticism of the staff and the public counsel, and you're willing to continue working to address those, I think you call it rate design issues, correct?
Correct.
And would you agree that the cost allocation is a little different than rate design?
Yes, I would agree.
So if, if we were to adopt a consistent methodology for the cost allocation as you did in your direct, we would need to determine the revenues to be recovered from each of the new classes, correct?
I believe so, yes.
Okay. And the way to, what you did in your testimony was you looked at the revenues allocated to each class, determined the percentage of overall revenues in the company's revenue requirement, correct?
Yes, I believe so.
And that, from that, you developed a percentage. And to determine the percentage of the annual securitization amount, you took the total annual bond requirement and applied that percentage for each class, correct?
Correct.
So these figures in your direct testimony and in the direct testimony of Witness Hall would need to be updated to show accurate percentages if you were to use your methodology proposed in direct. Is that right?
Yes, I believe so.
And we would also need to add the EV rate, is that correct?
I'm not for sure I can speak to the EV.
Okay. In the additional schedules that you filed, or were filed on your behalf last week, did any of those contain updated tables that might reflect what the percentage would be if the rate classes were updated?
Subject to check, I do not believe they did.
In your surrebuttal, well, let me think. You recognize the criticisms from staff and OPC and acknowledged the willingness to work towards resolving them. Were there any other issues that stood out in your mind that the staff raised that would need to be corrected other than the rate classifications?
I don't recall any other items sticking out to me, no.
Would you agree that within the context of a rate case, the first step to developing proposed rates is to establish the overall revenue requirement?
Yes,
And then would you agree that the next step is to allocate those costs among the various customer classes?
yes,
And typically, in a rate case, when you're allocating cost among classes, it will result in a different rate for each customer class.
that is my understanding.
And that closely follows what you proposed in your direct testimony here, that method, correct?
Correct.
The company chose to, after it did its cost allocation, you offer, I guess, a rate design that's based on a kilowatt hour charge for each class, correct?
Yes,
If you used a demand kilowatt charge to recover the allocated amounts, could that be done by individual classes?
I am not a class cost of service expert, so I'm not for sure I can answer that. I went and utilized the class cost of service and rate design that was proposed by our witness in the rate case.
And that was Mr. Lyons?
Correct.
And was that attached to any testimony in this case, that class cost of service? Or was it simply referenced within the testimony that you filed?
I believe it is just referenced.
Okay. And I believe you, in response to it may have been in your rebuttal, may have been a data request, the company agreed to use the updated class cost of service from Mr. Lyons' rebuttal in that rate case.
Check. Do you happen to have reference of which testimony that was in or a DR response?
I do have the DRs here. I think it was DR number 50 from staff. And I don't have a printout, I'm sorry, but I can read it. So the respondent was Karen Hall. And so the question was, refer to Karen Hall's testimony. Is Liberty's intent to update the calculations therein to reflect Mr. Lyons' rebuttal class cost of service in case ER-2022-0312 and the class usage values agreed upon in that case by the parties in the January 28th, 2022 non-unanimous partial stipulation agreement? And the response provided by Ms. Hall was yes, subject to and in accordance with the order from the commission in ER 2021-0312. So if we were to apply the company's proposed method, you would agree that those should be updated to reflect that class cost of service update.
Objection, compound question.
I'll have to sustain that if you could
Yeah,
simplify your question a bit.
I'll withdraw. Ms. Emery, if the Asbury plant were not retired and it were still online, some of those costs associated with it would be recovered through a demand charge. Is that correct?
Objection calls for speculation as to what would actually be ordered.
You want to rephrase your question?
Sure. Ms. Emery, Liberty Empire currently has generation units built into its rates, correct?
Yes.
And in its current rates, the value of those plants is at least in part recovered through a demand charge.
From my understanding from certain customers.
Depending on the customer class, correct?
You need to answer verbally, not just shaking your head.
Oh, yes.
That's all I have. Thank you.
Then for staff.
Ms. Emery, I think you testified earlier, not a class cost of service expert. Is that correct?
Yes.
Now, when page 19 of your rebuttal, you discuss legislative intent, correct?
Can you direct me to which specific line on 19?
Page 19, line 14 through page 20, line 9.
And restate your question, sorry.
You discuss legislative intent, correct?
I would object to the question. It assumes, I guess, something I'm not seeing in the testimony. Ms. Emery, in the cited sections, I think, talks about what she believes is unlikely.
Let me clarify the question, Your Honor. I think maybe I can.
All right.
You state at page, there you go. You state, page 19, line 18, you state, first, if the Missouri legislature intended for a debt-only rate to be applied, or if it had intended for the commission to impute some estimate of actual costs to finance certain expenses based on the assumption that such financing would be on a debt-only basis, it, meaning, are you referring to the Missouri legislature when you say it?
Referring to this statute.
It certainly would have indicated as much. That's what you state, correct? Are you aware that the Missouri Supreme Court has precedent that legislative intent is dictated by the plain language of statutes?
No.
So you didn't have any basis for what you believe the Missouri legislature intended, because you weren't aware that Missouri courts interpret legislative intent based on the language of the statute themselves.
My words were on my plain reading.
Now, you also, are you also aware that Missouri Supreme Court has precedent that statutes are to be interpreted in harmony with one another?
No.
Okay. So you weren't aware of that precedent when you were deciding what statutes allow and what they don't allow?
No.
Okay. In your net present value calculation and your direct testimony, at page 10, you do not consider what recovery of a 95-5 sharing mechanism under the FAC would show, correct?
Cite the page again
Page 10
of my direct.
of your direct in the 193 case, which is Exhibit 7.
Okay, and I'm on page 10.
Okay. So in your net present value calculation, you don't consider what recovery of 95-5 sharing under the FAC would show?
This is Dean Cooper from Liberty. I guess I'm not following the reference to page 10 of Ms. Emery's testimony in 0193.
Oh, I'm sorry, it would not be at 193. I believe it's, now, I apologize. It's Exhibit 8. It's your rebuttal. Page 10. Apologies.
Okay, I'm on page 10.
Yeah. So that table, table CTE2, that does not reflect a 95-5 sharing?
Correct.
Would you agree with staff's calculation that if the commission did order 95-5 sharing, that it would be approximately 10 million?
What would be 10 million? Sorry.
The difference in recovery.
Just want to make sure I answer your question. Are you asking if the 221,646 that's in my table would be reduced by 10 million? Or which balance?
the securitization balance of 175.
Oh, I'm sorry, I was looking at the wrong table altogether. Say the question again?
Yeah, would you agree with staff's calculation that if the commission did order a 95-5 sharing, that the securitization balance of 175 million would be lowered by approximately 10 million?
I believe that's accurate.
Okay. Okay. Now, you say in your rebuttal, in that case at page 16, that the company will pay taxes on the proceeds from the issuance of the securitization bonds. Is that correct?
And what row on page 16?
Rows 11 through 12.
Yes.
So when you say the company will pay taxes on the proceeds, you don't mean that the proceeds from the bond issuance, correct?
It is my understanding that it's based on the payments received from the customers that we would pay taxes on.
And that would be the payments that the ratepayers pay over time through the securitization charges, correct?
Yes.
Okay, so once the special purpose entity sells the bonds and Liberty gets the proceeds from those bonds, it doesn't pay taxes immediately on that immediate 100 million, 200 million plus.
That's my
correct?
understanding.
Okay. Okay. Do you have a copy or an Excel copy of your work papers?
I do.
Of your NPV work paper? Would you be able to open that up?
Yep. Give me just a moment.
No problem.
Did you want me to pull up the actual NPV calculation or the ADIC calculation?
The NPV calculation of ADIT.
Okay.
Mr. Stokes, while the witness is pulling that up, let me ask a clarifying question. This spreadsheet she's pulling up, is this what was marked as Exhibit 21?
Yes.
Okay, thank you.
I believe I have it pulled up.
Okay. Now on page 14 of your rebuttal, you discuss how to calculate the NPV, net present value of ADIT, correct?
Starting on line 10.
And beginning on line 15, you say, said another way, the annual cash inflows are equal to the amounts collected from customers, open parens, ADIT times ROR. Is that correct?
Correct.
And ROR, is that rate of return?
Yes.
Okay. Now, if you go to your work paper, it's all D13. That states securitization yield, correct?
Correct.
It does not state rate of return?
Correct.
And the securitization yield you have in there is 2.47, correct?
Correct.
And 2.47%, can you agree, is not a current accurate estimate for bond yields anymore?
I would have to ask Katrina on that.
Okay. Can you do me a favor and in cell D15, can you type in the number 4%?
Okay.
And does that move the net present value in cell E30 to 7.7 million?
Roughly, yes.
Now, rate of return is not the same as a bond yield, correct?
I believe that's accurate.
And when Liberty refers to its rate of return in other parts of this case, it's referring to its 6.77% weighted average cost of capital, correct?
Correct.
Can you type 6.77% into cell D15?
Okay.
Does that move the net present value calculated in cell E30 closer to 13 million?
12.9, yes.
And just one last question. Earlier, Mr. Opitz asked you about truing up class level revenue requirements. Do you recall that?
Yes.
I know that you've already testified you're not a class cost of service expert, but would you be able to explain step by step how to true up class level revenue requirements that are allocated for classes as you recommend in your direct testimony?
Not here today.
Okay. No further questions, Your Honor.
Moving over to public counsel.
Thank you, Nathan Williams. Good afternoon, Ms. Emery.
Good afternoon.
In your testimony, you refer to estimated decommissioning and estimated ROR, let me try it again, ARO costs, do you not?
In the Asbury, yes.
And what does ARO stand for?
Asset retirement obligations.
And what are those?
Those are essentially future costs that will have to be satisfied in the future.
Did you participate in estimating either the decommissioning costs or the ARO costs?
No.
Thank you. No further questions.
All right. Any questions from the commissioners on the online? All right, I do have some questions. First of all, when you were being questioned by MECG, I believe you used the term EV rate. What is an EV rate?
That's the electric vehicle, right?
Okay. And is that a rate that was just created in the last rate case?
There was a separate proceeding for it, but it was resolved through the rate case.
Okay, thank you. Now, Liberty is proposing to use a weighted average cost of capital of 6.77%. Is that correct throughout this case?
Yes.
Okay. And I believe that was approved, that's the weighted average cost of capital that was approved in Liberty's last rate case, the ER-2019-0374. Is that right?
Correct.
Now, Liberty recently completed a rate case. The rates went into effect just 2 weeks ago.
Correct.
Was there an approved weighted average cost of capital in that case?
No.
And do you know why not?
It was a silent settlement term.
Okay. Meaning it was part of a black box settlement?
Correct.
Okay. Is there any more recent data from what a weighted average cost of capital would be now rather than what it was during that earlier rate case?
I'm not aware of any.
Now, in your rebuttal testimony, Schedule CTE 3 and Schedule CTE 3 Storm Uri, the Asbury and Storm Uri calculations, they use a carrying cost of 2.47% for securitization and 6.77% for the weighted average cost of capital that we were just talking about. They seem to be from different time periods. In that the 6.77% was from the 2019 case, and the 2.47% was based on situation in, I believe, in January, or for when the direct testimony was filed. Is there any problem with conducting a NPV comparison using costs from different time periods like that? You know, is there a way of getting around that?
Not exactly sure. I'm sure each party, I know everybody can put their own amounts in there, and I feel like some of the parties have used different rates.
Which is what staff just did, right?
Yes, yeah.
Okay.
So you can use different rates, but I'm not sure that I think it gets you a different result, of course, because it's a different input, but I'm not aware of.
Okay, and the inputs can still be changing it all throughout the process, right?
Correct.
I want to talk a little bit about the fuel adjustment clause. It's my understanding that Liberty is not attempting to recover Winter Storm Uri costs through its FAC, is that correct?
Correct.
If the company would have sought recovery of Winter Storm Uri fuel costs above those contained in current rates through its FAC, instead of pursuing securitization or an AAO, what percentage of those costs would the company have been allowed to recover?
Well, I'd have to say it wasn't eligible to go through the FAC. There is a rule that guides the FAC, and it says that if there was a cost that's deemed extraordinary, you couldn't flow that through the FAC.
Okay. At what dollar amount or percentage of company revenues do FAC costs become extraordinary, and how is that amount determined?
Well, I'm sure that's subject to various opinions. The company, when we actually filed our fuel clause, immediately right after Storm Uri, because our fuel clause filing was due on April 1st, Storm Uri occurred in February. We took the approach that anything above what the commission had approved for base rates would be deemed extraordinary.
Okay, and who made that decision?
It was brought forth in our testimony, the company's testimony, and ultimately that's the decision that allowed the amount to be put into the FAC, or in this case excluded from the FAC.
You're talking about the testimony that was filed in the FAC case?
Correct.
Now, talking about the tariff, in reference to your rebuttal testimony on page 39, regarding a recommendation for parties to collaborate and agree on a form tariff prior to the financing order being issued, what timeline and process is Liberty proposing for negotiating that tariff?
It's my understanding that the tariff itself doesn't necessarily need to be in effect. It just needs to be in effect before we start collecting the bonds. So I believe the allocation needs to be contained within the financing order. So I would be envisioning the time frame between when the commission issues the order on financing and the time frame of when we need to start collecting that.
So it would be after this decision
Correct.
that's coming out of this case, okay. And have the parties gotten back to you about that?
I have not heard anything.
And if they were not able to settle this through this informal process, how would you proceed to bring it to the commission for decision?
Well, this is our first time doing this, so I'm not exactly sure of the process that would need to take place there.
There was, in Kim Boland's rebuttal testimony, there was an issue raised about interest earned on capital sub-accounts. This was not listed as an issue in the list of issues. Do you know if that was resolved somehow?
We were fine with staff's recommendation on that.
Okay. All right, that's all the questions I have. Recross based on questions from the bench then, Renew Missouri,
No questions, thank you.
MECG,
No, thank you, Judge.
all right, for staff.
Very briefly, Kurt Stokes for staff. Would legal costs be recoverable through an FAC clause?
I don't believe so.
Would you agree that OPC challenged the level that Liberty identified as extraordinary in case ER-2022-0332, Liberty's FAC filing?
I recall an alternative being presented by OPC, but ultimately the rates or the amount that was removed from the FAC was allowed to take effect.
Right. And that was, Liberty didn't get to decide on its own without an order from the commission what qualified as extraordinary, correct?
Correct.
Now, would you agree that Liberty would be incentivized to, if it wants to recover 100% of fuel and purchase power costs during an extreme event, to set the threshold for what qualifies as extraordinary as low as possible?
Can you rephrase that?
Yeah. So would you agree that Liberty would be incentivized, if an extreme weather event occurs, to set the threshold for what qualifies as extraordinary at a very low level in order to qualify for 100% recovery?
I don't believe I would agree with that.
Then why did it do it here?
We made the best estimate of trying to estimate what those costs were.
Why did you oppose OPC's higher level threshold for extraordinary costs?
Just like their estimate was, it was an estimate.
Would you agree that in the future, ratepayers would be incentivized to set the threshold for what qualifies as extraordinary as high as possible to avoid having to pay 100% of those extraordinary costs?
I'm not for sure customers. Say the question again.
Would you agree that ratepayers in the future would be incentivized to advocate for a higher threshold for what qualifies as extraordinary in order to avoid paying 100% of extraordinary costs?
I think there's a lot of factors that can come into that.
Would one of those factors be savings under the securitization statute?
Can you define savings underneath the securitization statute?
Yeah, so interest rates being lower under the securitization statute than carrying costs under the FAC or long-term carrying costs under an AAO.
I would imagine a customer would be better served by a lower interest rate, yes.
Mm-hmm. So the being better served by a lower interest rate would be offset, though, by recovering 100% of those fuel and purchase power costs instead of sharing in 95% of those fuel and purchase power costs.
The cost that was incurred by the company during the extraordinary event was prudently incurred by the company. We paid those costs on behalf of our customers, and we have made every attempt to save customers as much as we possibly can in regards to that event.
Are you aware that in previous cases, different parties have advocated for a sharing mechanism other than 95% for fuel and purchase power costs?
Yes, I'm aware.
Has the commission ever found a percentage other than 95% just and reasonable?
That, I'm unaware of that.
No further questions.
Public counsel?
Thank you. Nathan Williams for Public Counsel. Did not Liberty in the FAC case for the accumulation period that includes February of 2021, which is the period when Storm Uri occurred, set the amount to be collected based on an FAC charge being 0?
The FAC rate that was allowed to take effect did have a 0, was at 0.
And that's what Liberty proposed, is it not?
Liberty proposed it and the commission approved it.
And all that rate did was say what amounts were considered to be, that the amounts that were going to be collected were not extraordinary, correct?
Say that again, please.
The only thing the commission approving that rate indicates is that the commission agreed that the amounts to be collected under that rate were not extraordinary, correct?
What the commission approved was an amount that the company did not allow to flow through the FAC.
I think I made my point, thank you.
All right. Then redirect.
Thank you, Your Honor. Dean Cooper for Liberty. While we're on the subject of the 95-5 sharing here, you were asked by staff counsel about whether I think it was your NPV calculation included a 95-5 sharing provision. Do you remember that?
Yes,
And I believe you said it did not.
correct.
And to your knowledge, does the securitization statute mention any sort of sharing?
No.
You were also asked about, and again here in the last couple of sets of questions, in your opinion, if fuel and purchase costs are extraordinary, does the FAC rule permit them to be recovered through the FAC?
No.
Your Honor, the witness answered before I could object, but I would object to and move to strike as calling for a legal conclusion.
Overruled.
Now, in terms of the process in the FAC, it's true, I suppose, that the company makes a proposal when it files its FAC, correct?
Correct.
And other parties have the opportunity to review the company's proposal?
Yes.
And I think it's been mentioned here that in fact in your last FAC, perhaps one party took a different view of that, correct?
Not in the FAC filing directly following the storm event, yes.
But in the end, whose decision is it, what flows through the FAC?
The commission.
And I think that relates also to some questions that you got from Mr. Stokes about what the company is incentivized to do in regard to where it views not extraordinary and extraordinary to land. Again, ultimately, is it Liberty's decision where that line is drawn?
No.
And in terms of incentive, is it true that the recovery period under the FAC is extremely short?
Yes.
How short?
6 months.
So if one were to think about the recovery of 193 million over a 6-month period, would that be a pretty extreme impact for your customers?
Yes.
And would that also figure into the company's decision as to what it proposes in terms of where the line between not extraordinary and extraordinary would be drawn?
It did.
Sorry, Your Honor, give me just a moment. I'll check my notes here.
That's all the questions I have. Thank you, Your Honor.
Thank you. Then you can step down.
Thank you.
And we're due for a break. We'll come back at 3 o'clock. All right, before we go to the next witness, I do have one thing I want to bring up with staff. I want to give you a warning of a question that we're intending to ask tomorrow. It's about the Asbury AEO regulatory liability, about the value of the liability. Your position statement says it's 75.8 million, and we intend to ask some questions tomorrow to try and find the basis for that. So just to be forewarned. All right, the next witness then is John Olson.
Thanks, Judge. We would call John Olson to the stand.
Thank you. Please raise your right hand. Do you solemnly swear or affirm testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may inquire.
Please state your full name.
John Olson.
By whom are you employed and in what capacity?
I'm a consultant for Utilicast.
And what do you do as a consultant for Utilicast?
We do a variety of things. We do a lot of work for utilities in evaluating their operations and helping them out with things with their transmission service, distribution services.
And did you prepare and file testimony on behalf of Liberty in this case?
I did.
And was your testimony pre-filed and marked as Exhibit 9 public and 9 confidential?
It is.
Do you have any changes for that testimony?
I do not.
If I asked you those same questions today, would your answers be substantially the same?
They would.
And are those answers true and correct to the best of your information, knowledge, and belief?
They are.
I would move for the admission of Exhibits 9 public and confidential and tender the the witness for cross-examination.
All right, exhibits 9P and C have been offered. Any objections to their receipt? Hearing none, they will be received. For cross-examination, beginning with Renew Missouri,
No questions, Your Honor. Thank you.
MECG,
No, thank you, Judge.
for staff.
Thank you. Kurt Stokes for staff. Mr. Olson, Utilicast entered into a contract with Liberty Utilities for this case, correct?
We entered into it for reviewing their operations, yes.
And pardon me just a second. The original consulting services agreement, page 10, one of the provisions is that the consultant will share draft findings and recommendations for each area with company team leads prior to inclusion in final draft report. Is that correct?
That sounds correct. I don't have the agreement from me, so I'll have to go by memory.
Okay.
If I question it, I'll have you provide them for me.
Okay. Do we have the copy that I gave to you?
Consulting, and I do, and I'd like to hang on to it. I think you have it also. There you go.
Do we have a copy I could share with you? Permission to approach the bench and the witness.
You may.
Okay, I've handed you a document with the title Consulting Services Agreement, Addendum Number 1 at the top. Does that refresh your recollection?
For the addendum, yes.
Okay. Now, at the top of page 3, you agree that the contract says consultant will share draft findings and recommendations for each area with company team leads prior to inclusion in final draft report. Is that correct?
Yes, it does.
And deliverable 1 is the incident analysis report you just mentioned.
Incident analysis report, so
Yeah, so a draft of the detailed incident analysis report to be provided for review by
Yes.
company management.
Yes.
Okay. Deliverable 2 is written testimony, to provide written testimony from the Utilicast project lead with a summary of the findings of the incident analysis report for inclusion in the Missouri Public Service Commission rate or securitization proceedings.
Yes.
Okay. No further questions, Your Honor.
All right, public counsel?
No questions, thank you.
All right. Any questions from the commissioners online? Okay, I do have some questions. The first question is about the Utilicast report submitted in Schedule J03 of your direct testimony. On second paragraph, third sentence states, well, it goes into the discussion about the Empire working with the Kansas Department of Health and Environment to obtain a force majeure waiver. My question is, can you explain what test fired means in that context? And under what conditions a test fire occurred for Riverton 10 and 11?
So I'm trying to, I'm sorry, I missed the page. I was stumbling around here. I should put my
Page
glasses on.
20, page 20 of the Utilicast report, it's scheduled J03 of your direct.
Okay.
Second paragraph, third sentence. And it's talking about the test
Test
firings.
fires, yes. So for our evaluation, a test fire would be that the unit could be demonstrated to at least fire, have combustion in it, and be ready to run. Wouldn't necessarily sync to the grid, but it would have the fuel source going through it, spinning the turbine and having it ready to be synced to the grid and then possibly pick up load.
Okay. Now, these two units would normally run on gas, correct?
That's our understanding, yes.
Okay. And were they in fact running on gas before the gas supply was interrupted?
Trying to remember, I think Riverton 10 was. I'd have to go back and look at some of the analysis for Riverton 11, but Riverton 10 did have a issue that took it offline during the time period.
Yeah, I understand.
But I think they were both operational prior to, if gas was available, I think both of them would have been operational. But that may be a better question for the Liberty witnesses.
And I think that I've also seen the term, it was not tuned for low temperatures. Can you tell me what is meant by tuning in that context?
It'd be similar like your car, trying to calibrate well, we used to have the old the carburetors, right, on cars and stuff that we tune those. So if you're on natural gas, it uses a different set of combustion process than it would if it's on diesel fuel. And that's about as technical as I can get for you.
Okay.
So, but tuning would be where you would ensure that it have dependable operations through all ranges on that particular type of fuel source.
Okay. Now, I've seen some contexts, it's talking about fuel oil, and you just mentioned diesel. Which is it?
Both. It's the same.
Okay, fuel oil is diesel.
Yeah, it's a specific grade of diesel.
Okay. Now, is it possible to tune for low temperatures when the temperatures are not low?
No.
So the only way you can tune for below zero temperatures are when the temperatures are below zero?
That would be my understanding, yes.
Okay. Can you tell me which month Riverton 10 was tested in 2021 and Riverton 11 in 2016?
I don't know if we've covered 21 in our
I'm sorry,
report.
I misspoke. The Unit 10 was successfully test fired on fuel oil in 2020. And Unit 11's was last successful test fire was in 2016. So it'd be 2020 and 2016.
Okay. Those dates sound correct.
Do you know which months they were tested?
I do not.
I believe that's all the questions I have. Any recross based on those questions from the bench? Okay, I don't see anybody stepping forward. Any redirect?
Yes, thanks, Judge. I would also just note, most of those questions you asked, if you want to ask them of Dr. Mashimba tomorrow, that will be his area
Okay, thank you very much.
expertise. Thank you. So, Mr. Olson, you were asked about your contract with Liberty, your consulting services agreement. Do you still have that with you?
The addendum, I do, yes.
Curtis, do you have the other one? There we go. May I approach, Judge?
You may.
Thank you.
Okay.
You were asked about the deliverables on the consulting services agreement. Do you remember those questions?
I do.
Those deliverables apply to a scope of services, is that correct?
That is correct.
And what was the scope of services? What were you to do?
We were to review the operations of the utility during the Winter Storm Uri events.
Were you specifically asked only to find things in favor of the company? For example, as a testifying witness, were you to identify only those things that the company did well?
No, I'd actually say we were probably even challenged to find things more so that the company wasn't doing well. That was one of the first requests that came to me was we want a thorough review of the company's operations, finding out what we do good and what we don't do good and where we can improve based on the industry experts that we have at Utilicast and their experience with others.
You were asked about one specific requirement in the consulting agreement, that a draft be provided to Liberty. What was your understanding of why a draft would be provided?
We were willing to provide the draft to Liberty to ensure that the data that we were reviewing, because it was a lot of previous filed testimony, and then also some interviews that we were doing, that we were capturing that information correctly and presenting it correctly, so that we didn't have just a misstep, if you will, in how we prepared the documents or how it was put together. So I liked that approach to make sure both parties understood what the document was saying.
Thank you. That's all I have, Judge.
Then you may step down, Mr. Olson.
Thank you, sir.
And Mr. Olson traveled in. May he be finally excused?
You may be excused as well.
Thank you.
Have safe travels. That actually takes care of the witnesses for today, and I believe we had, Mr. Rooney was to be available if we had time, and it looks like we have time.
And he is available.
Okay.
So we will call Sean Rooney to the stage.
All right, Mr. Rooney, if you please raise your right hand. Solemnly swear or affirm testimony about to give in this matter is the truth, the whole truth, and nothing but the truth.
Yes, sir.
Thank you. You may inquire.
If you will please state your full name.
Yeah, my name is Sean T. Rooney.
By whom are you employed and in what capacity?
I'm employed by Liberty Utility Service Corp. as the Senior Manager of Strategic Project for Liberty Central Region.
And does that include the Empire District Electric Company?
Yes, it does.
Did you prepare and have pre-filed in these dockets certain testimony and question and answer form?
Yes.
And have those been marked Exhibits 11 and 12?
Yes.
Do you have any changes for that testimony?
No, I do not.
If I asked you those same questions today, would your answers be substantially the same?
Yes, they would.
And are those answers true and correct to the best of your information, knowledge, and belief?
Yes.
I would move for the admission of Exhibits 11 and 12 and tender the witness for cross-examination.
All right, 11, 12 have been offered. Any objections to their receipt? Hearing none, they will be received. And for cross-examination, again, we begin with Renew Missouri.
No questions from me.
MECG? And for staff,
Kurt Stokes for staff, I have no questions.
okay. For public counsel,
Nathan Williams, no questions.
all right. I do have some questions. Oh, let me first ask if there's any questions from the commissioners online. All right, for my questions then, why did Liberty discontinue self-commitment of Asbury?
As I stated in my testimony, give me just a moment. So in the past, Asbury was self-committed to satisfy conditions of our coal transportation contracts, which required us to receive a certain amount of deliveries on an annual basis. However, the practice of self-committing large units, especially in conditions under which they're not economical, is to basically force out less costly generation that would have otherwise been dispatched, thereby raising the cost of energy for all consumers.
What's the impact of that on the bottom line of the company? Does the company lose money also if they're self-committing?
That opportunity does exist, yes.
Opportunity to lose money, you mean?
Correct, yes.
Okay. If customers are, if your ratepayers are losing money, you're losing money as well, is that?
Generally, it's when, the market prices don't support our cost of generation. So we're, taking a price that's below our cost to create the generation.
Okay. I think I understand how that works, but could you explain that for me?
Yeah, for example, if our cost to generate a megawatt hour of electricity is, $32, and the market price at our location at that time is $27, we, lose $5 on every megawatt hour generated.
So you might be generating electricity at a cost, selling it for less than what you'd cost to generate it.
Exactly.
Which costs you money as well as the ratepayers. Okay. When you in your testimony at page 4, lines 5 through 7 of your direct testimony, you stated this practice, and would be self-commitment, had the potential to increase customer costs. If Asbury self-commitment displaced other low-cost generation, did it actually increase customer costs? Or do you know?
I would not be the correct witness to answer that.
Who would be?
Somebody like Witness Dole.
Okay. Was a cost-benefit analysis conducted to assess the impact of continuing with self-generation or discontinuing self-generation?
I'm not aware of any cost-benefit analysis that was done looking at the risks associated with continuing self-commitment of Asbury.
Okay. Again, on page 4 of your testimony, you stated after discontinuing self-commitment of Asbury, the unit's annual capacity factor began to decline as the market selected units with better heat rates, lower fuel costs, shorter start durations, shorter minimum downtimes, and faster ramp rates. Now, given that Asbury was not operating as baseload, would not the declining annual capacity factor be expected?
I'm sorry, could you repeat that, please? I'm not sure
I'll try.
caught it.
Since Asbury was not operating as baseload, would the declining annual capacity factor be expected?
Certainly, a former baseload coal plant that was no longer operating as baseload, would certainly have a lower capacity factor.
Okay. And how does Asbury's discontinuance of self-commitment impact its marketability relative to heat rates, fuel costs, start durations, and ramp rates?
Right, so when you self-commit a unit, you kind of put all those characteristics of a generating unit that influence how it plays in the market, and you just set those aside. And you just say, we're going to generate. So when we stop doing that and we say that we are going to go strictly on market signals, then we have to compete with other units. You know, if a unit has a lower heat rate, you know, all things being equal, it's going to be more efficient at generating electricity, and it's going to win out in a market situation. You know, some of the things about you know, minimum downtimes, minimum commitment times, make a unit less agile in the market. So you might commit to the market in a condition where the unit can make money, and then be required to stay on for a longer period of time through your minimum commitment time. And maybe those conditions that were supportive of your operations at the beginning don't exist towards the end of your run. So generally, units with, you know, better heat rates and units that are more agile in today's marketplace, they just play better.
Okay. Now, let me clarify something just to make sure I correctly understand the self-commitment process. When you self-commit something, your coal-fired unit, for example, you're saying, we're going to run this no matter what, and we're going to take whatever the market price would be.
That's correct.
So, and that's why the market price might be lower than what your actual cost of generating electricity is.
That's correct.
Okay. I have to write this all into an order, so I want to make sure I have it right. Okay. Did Asbury self-commitment discontinuance make it less cost-effective?
I would say that, yes, generally, it's lower generation volumes, you know, because you do have a large fixed cost component at the Asbury plant associated with, you know, one thing you have at a solid fuel plant is a large staff. You know, those costs have fewer units of production to be spread over. And so, yes, the unit does become, you know, less cost effective on a per unit basis.
Just in general, what kind of units would be more cost effective under those kind of situations?
Well, I mean, renewable energy not having, you know, a fuel cost component. Obviously, we have a number of natural gas units that, you know, from an employee count standpoint, you know, are, you know, they don't have that higher fixed cost burden. You know, natural gas has in recent years been a cheaper fuel on per unit of heat input than coal was. Then on top of that, you take, you know, a coal unit with a heat rate between 10 and 11,000 BTUs per kilowatt hour, and you put it against a combined cycle unit that has, you know, 7,800 BTU per kilowatt hour heat rate. You know, just all of those conditions are just in favor of those other units with respect to coal.
Okay. Now, comparing just coal units, how competitive was Asbury with other coal-fired units?
It was actually the least efficient coal unit in Empire's fleet.
How many other coal-fired plants are in Empire's fleet?
We are part owners of 3 other coal units, so the Iatan units 1 and 2 up in the Kansas City area, and then Plum Point down in Arkansas. All those facilities are newer than Asbury. There's some economies of scale with those plants being much larger, Asbury being only 200 megawatts, and each of those being over 600, so, you know, 3 times the size. In the case of Iatan, you have, you know, I talked about employee count. You have the same group of employees operating 2 units, so there's some efficiency there. So there's just a lot of savings opportunities for larger coal units that just aren't there anymore for a smaller coal unit of Asbury's age.
What about comparison to other coal units that are not owned by Empire but are in SPP?
I'm not familiar with the heat rates of, you know, every single unit in the SPP, but
Is that something that's confidential that you wouldn't even necessarily?
No. I think there's heat rate data that's been filed in my testimony. But what I would say is, you know, consistent with my last statement, that based on its age and its, relatively small size, that it would be, in my opinion, it would be among the lower ranks in terms of coal plant heat rate efficiency in the SPP.
Okay. And heat rate efficiency is the basis for bids into the SPP?
It's a factor. I mean, your heat rate is your conversion factor, right, for fuel to electric energy. So, it plays a factor in what your fuel cost is in per unit of production.
Okay. That's all the questions I have then. Any recross based on those questions from the bench? Public counsel in?
Thank you, Judge. Nathan Williams. Mr. Rooney, you recall questions asking you about self-commitment at Asbury and the impacts on Empire?
Yes, I recall.
Are those impacts to Liberty and Liberty's customers the same?
In what respect?
Aren't Liberty's shareholders insulated by the fuel and purchase fuel adjustment clause?
There is a cost sharing in the fuel adjustment mechanism, yes.
So if Asbury were less efficient in terms of it was a higher cost than market at some point in time, shareholders would, let's make it, be insulated for 95% of that, correct?
Correct.
And the efficiency or the difference between market and cost to generate varies over time throughout the year, correct?
Yeah, that's correct.
So what might be costly on a window less than a year period of time might be cost effective over an annual period?
I would agree theoretically, yeah, that's possible.
And do you agree that Asbury had value for its reliability as a resource of energy?
Yes, Asbury had some value as an energy resource.
Well, with having on-site coal, wasn't it more reliable for having energy than, say, a wind resource?
There are certainly reliability benefits to having a coal stock or a fuel stockpile on site.
And that's my point. Thank you.
All right, redirect.
Yes, thank you, Judge. Mr. Rooney, I believe you pointed to Aaron Dole as the person who would be most knowledgeable on the self-commitment issues. Is that correct?
Yes.
Are you familiar that the commission had a docket open to investigate the self-commitment issues?
Yes, I was aware of that.
And did Empire participate in that docket?
I do not know that.
The negative financial impact that you were asked about by Judge Woodruff and Mr. Williams, am I correct that the financial impact would be smaller to the company because of the FAC, but more significant on the customer then, the potential negative impact of
Yes.
self-committing?
Yes.
And did the company take steps to minimize that impact on customers?
Well, we ended the practice of self-commitment. That took, I think it's in my testimony, we went through the efforts of, renegotiating coal contracts and coal transportation contracts to make sure that we could operate in a way that, our customers were, we were seeing positive economic benefits from Asbury when it operated, and that those flowed to our customers.
You said on your testimony, I believe in response to a question from Judge Woodruff, that other facilities besides Asbury just play better. What do you mean by that?
Yeah, I mean, it's a competitive marketplace. There are a number of unit characteristics that influence how a unit performs in the market. You know, which units, maybe get committed more often, maybe they have better margins. But generally what we've seen is, the classic baseload coal unit, it doesn't work the same way it used to. Markets are different. I mean, this is really a marketplace for more agile units.
And does continuing to operate a plant that doesn't play well, does that lead to higher customer costs?
It certainly can. And, we did take measures that are also detailed in my testimony. Boiler tuning, which helped us unlock, some faster ramp rates on the turbine. We really took a close look at what we needed to do with startup and shutdown procedures so that we could reduce our minimum commitment time, so that we could reduce our minimum downtime, to try and make that unit, it would enable us to operate in more than just the conditions that we had used to operate under. During significant portions of the year, there were still times we could operate the way we used to, more of a baseload type. Back in the mid-2010s, we used to have very long continuous generation runs at Asbury where we'd run 200 days. Your continuous runs were much, much shorter, kind of post-2017. I think maybe 45 days, something like that. And then rather than have the unit sit idle in those months where that type of operation was not supported, we took the measures that we took, new standard operating procedures and trainings for operators, boiler tuning, all those things to unlock some of the agility that was available in that unit.
Ultimately, though, the decision then was still made to retire Asbury?
Yeah, that's correct. I mean, despite our efforts, the unit's capacity factor continued to decline. We did have a record number of starts in the last few years of operation, so we did have some success with the measures that we took, but ultimately, those measures were not enough to return Asbury to economic viability.
Thank you, that's all I have.
All right. And then Mr. Rooney, you can step down.
And Judge, Mr. Dole is here if you were to want to ask him the questions on self-commitment.
Not necessary.
Thank you.
Okay, I believe that's the last witness then for today. We'll resume at 8:30 tomorrow. Anything anybody else wants to bring up before we adjourn? All right, then we're adjourned until tomorrow.